Excellent. Good afternoon and welcome to Subchapter V, 2 years after enactment, perspectives from the bench and a Subchapter V trustee. I'm Garrett Warrington. I'm the chair of the BHBA bankruptcy section, and I'm pleased to introduce our speakers today, Judge Paul Bonapfel and Mark Sharf. Judge Bonapfel sits as a bankruptcy judge in the Northern District of Georgia, and Mark is a Subchapter V trustee in both the Northern and Central Districts of California. Their bios are in the written materials, but suffice to say they're both experts in Subchapter V, the subject of our program today. Today's program is going to be an open format where we're going to ask you to ask your questions in the chat just as soon as you think of them. So there's no need to wait till the end to ask your questions. Just fire away once you think of it. Finally, CLE certificates will be emailed to the participants and the audience as soon as the program ends. Let's jump right in. I'm going to give the floor over to Judge Bonapfel to discuss his top 10 features of Subchapter V. Judge.
Thank you, Garrick. First of all, this may be an East Coast thing, but I say Subchapter 5. So y'all have to excuse me for that. So we've got, just as a refresher, the top 10 features, I think, of Subchapter 5. And the first one, if you'll go to the next slide, is eligibility. As originally enacted by the Small Business Reorganization Act, eligibility was found in section 10151D, which defines a small business debtor. And so the statute said that a small business debtor who elected sub 5 could be in sub 5. That statute did not change the debt limit of $2,725,625. In response to the COVID pandemic, however, the CARES Act increased the debt limit temporarily to $7.5 million, and it put the eligibility requirements in 1182(1). That sunsets on March 27, 2022. And unless Congress does something, the debt limit will go back to the 2,000,007 and change number, and the definition will go back to 10151D. Fortunately, the operative language, both sections, is the same. So the debt limit is based on the aggregate secured and unsecured non-contingent liquidated debts. It includes debts that affiliates owe. It does not include debts that are owed to an affiliate. In determination of what is contingent and liquidated, there's a case called Parking Management that ruled, among other things, that PPP loans and lease rejection damages arising from the rejection of a lease are contingent or unliquidated and not included in the limit. So the other eligibility requirements in general are the debtor must be engaged in commercial or business activities. The cases have given that a rather broad scope, including winding up a business, and at least 50% of the debt must arise from commercial or business activities. Then there's a couple of specific exclusions. One is a debtor can't be a public company or an affiliate of a public company, and a debtor can be engaged in the real estate business, but cannot be a single asset real estate debtor. So next slide.
I want to say something real quickly about that last slide. The debt limit of 7.5 million, which may revert back to 2.7 million. In calculating that, you don't include debts that are contingent, and you include liquidated but not unliquidated. And those terms have been used for decades in Chapter 13 and I believe in Chapter 12 as well. And there's a whole host of Ninth Circuit bankruptcy appellate panel decisions interpreting those words. So, for example, taxes. Let's say you haven't filed your tax return yet. It's a recent year. There are cases in the Chapter 13 context saying that as soon as the IRS assesses the taxes, it becomes liquidated. So, you file the day before, that's not included. The day afterwards, it is included. There are cases saying that admissions and lawsuits as to a portion of the debt being owed. If the debt is owed, if they lose, what is the damage amount? If a portion of it was admitted to, not the liability itself, just the calculation of damages, that's counted also. That portion is counted. There's Ninth Circuit bankruptcy appellate panel cases on this if you look back in the Chapter 13 records. And also, of course, the general rule that debt is liquidated if the bankruptcy court can determine the amount owed in a short hearing, maybe 2 to 3 hours, not 2 to 3 days. And that's sort of Ninth Circuit practice. And so it's really critical to do the Chapter 13 and Chapter 12 research. I'd recommend that you look at Judge Bonapfel's Chapter 13 treatise on the Westlaw. Judge London has another one. But the law has already been established in very similar circumstances, same statutes, same words. They probably apply here as well. It's definitely worth taking a look at.
All right. Thank you, Mark. Point number 2. A trustee is appointed in every case, but the debtor remains in possession. So this is like Chapter 12 and 13 cases. The debtor can be removed from possession for cause. And an important point is that the trustee has the duty to facilitate the development of a consensual plan of reorganization. The trustee does not have such a duty in any other chapter of the bankruptcy code. So number 3, here's one for general rejoicing throughout. If we go to the next slide, there are no U.S. trustee fees, which the slide says is quarterly fees because I did this in a place where they don't have a trustee. Number 4 is there is no committee of unsecured creditors unless the court orders otherwise. 5, I've never seen the court order otherwise. 5, there is no requirement for a disclosure statement to be filed or approved in connection with voting on the plan, again, unless the court orders otherwise. The plan, however, must contain a brief history of the operations of the debtor, a liquidation analysis, and projections with regard to the ability of the debtor to make payments. Number 6, speaking of plans, only the debtor may file a plan and must do so within 90 days of filing unless the court orders otherwise. There is no deadline for confirmation of the plan, however, which makes it different from a small business case, which did impose a deadline for confirmation after its filing. Number 7, the cram down rules are changed in a couple of ways. First, the plan may be confirmed even if no creditor accepts it. There's no requirement that any impaired class accept it. And also important, the absolute priority rule does not apply. There is a requirement for payment of projected disposable income to make plan payments for a period of from 3 to 5 years as the court determines. And this requirement applies to a business as well as to an individual. The cram down rules for secured creditors are unchanged. Number 8, consequences of confirmation differ on whether the plan is a consensual plan confirmed under 1191A or a cram down plan confirmed under 1191B. In a traditional Chapter 11 case, the type of confirmation doesn't matter. It does matter in Subchapter 5. The differences relate to the timing and scope of the discharge, who makes payments under the plan, and whether the estate includes post-petition assets and earnings. Number 9, a Subchapter 5 plan may modify a residential mortgage if the loan was not primarily to purchase the property and if the loan proceeds were primarily used in the debtor's business. Think, for example, an SBA mortgage on the residence to secure a business loan. This cannot be done in any other chapter if there's equity in the property. Number 10, property of the estate does not include post-petition assets or earnings because Section 1115A is inapplicable. Section 1115A in a traditional case makes property of the estate and post-petition assets of an individual property of the estate just as it is in a 13. This means a couple of things. First, the debtor can use an individual. For a corporate debtor, this doesn't really make any difference. For an individual debtor, the debtor can use post-petition earnings without court approval. Second, the automatic stay does not prevent collection of a domestic support obligation or post-petition debt through wage garnishment. And finally, this is very important for individuals, if the case is converted to Chapter 7 prior to confirmation, the Chapter 7 estate in the individual's case does not include post-petition earnings and property. This is not the rule in a traditional Chapter 11 case after BAP-CPA in 2005. So that's the top 10.
All right, so we have a question from the audience. Are Subchapter V cases increasing across the country, or are they on the rise? You guys have a thought on that?
I can tell you that when the statute was first passed, there was a big rush of cases. People were waiting for the statute to pass. People were redesignating existing Chapter 11s as sub-V cases. Things were then progressing at a pretty modest pace, not that many cases, until this March, because this March, everyone thought that the $7.5 million eligibility number was going to go back down to 2.7. There's a big rush of cases. And then since March, it just retreated to a pretty modest level. I think because of the eligibility of the existence of pandemic loans, emergency grants for businesses, things have been pretty tame overall. Not that many cases.
Yeah, all filings are down. They're really hot in Florida. The Middle District of Florida and the Southern District of Florida, I think, are two of the largest countries by number of filings in the country.
Interesting. Okay, so
roll the Subchapter 5 trustee. I'm going to take the laboring oar on that one. There are a lot of different philosophies about the role of the Subchapter 5 trustee. And I'm also, I'm in court all the time. I see what other trustees are doing. I speak with them privately. I speak with people over at the U.S. Trustee's office, and the U.S. Trustee's office has their own publicly available publications on what it is that a Sub-5 trustee is supposed to be doing. But then there's the statute, and I think you always start with the statute. The statute gives the Subchapter 5 trustee, the ability to object to claims, to oppose a discharge if warranted. Sub-5 trustees are required to give information to parties in interest. But here's the interesting part. This is all specified in Section 1183B. It says the trustee shall, so these are things the trustees are required to do. It says the trustee shall appear and be heard at the status conference, and then at any hearing regarding the value of property subject to a lien, confirmation of a plan, then later on plan modification, and the sale of property of the estate. So, hearings regarding value of property subject to a lien typically is a relief from stay hearing. And to me, the key language of the statute is that the trustee shall appear and be heard. And that's significant for a couple of different reasons. First of all, I've seen some trustees just show up and have nothing to say. I think that's an abrogation of the duties. You are required to have an opinion, to appear and be heard, to take a stance, to take a side. It's right there in the statute. Secondly, the Ninth Circuit back in 1995 decided that Chapter 13 trustees have standing to object to plan confirmation because Section 1302 of the Bankruptcy Code says that they have the right to appear and be heard at confirmation hearings. And what that means to me is that the Ninth Circuit would pretty clearly rule that Sub-5 trustees have standing to file objections. So Sub-5 trustees are out there. Their opinion matters. They're sort of informal advisors to the court. Put it this way: Sub-5 trustee is the only person who's besides the debtor and the debtor's lawyer who's there at the initial debtor interview, as well as the creditors meeting, as well as the status conference. The judge wasn't at the IDI nor at the 341A meeting, and they're not privy to all the financial information that's being investigated. I've noticed, by the way, judges expect Sub-5 trustees to carefully review and know the contents of the monthly operating reports. They're supposed to be financial experts, which is interesting since almost every Sub-5 trustee I know is a lawyer and not an accountant. But nevertheless, we're supposed to be good with numbers. We're supposed to be giving that kind of opinion. So appearing and being heard is critical. And I have to tell you, when there's a close call and a judge doesn't know what to do and they're 50-50, they'll usually go with what the sub 5 trustee recommends. And what that means is that if you're a debtor's lawyer, you should be running everything by the sub 5 trustee. Before you file a motion, you should send it to the sub 5 trustee, the plan. God, when I get plans a week in advance, I tell you, I'll review them, I'll give all my comments. And for the debtors who incorporate the comments, or at least most of them, I don't object. And for the debtors who never run it by me, I'll have many objections, and I'll try to resolve them by way of stipulations that haven't actually filed an objection. But I have filed objections, many objections. So, take that into account. Also, sub 5 trustees probably have more experience with this new chapter than anybody. I mean, between Orange County and Northern California, I've probably already been involved in about 35 cases. That's a lot. Probably at least 10 have been confirmed. So I can actually help. Also, take into account the fact that sub 5 trustees get paid the same way debtors lawyers get paid. They get paid either upon plan confirmation, or if it's a non-consensual plan, perhaps payments over time. But the point is, there's this sort of built-in incentive in the code for things to work out, for those plans to get confirmed. That helps. So, the trustee is not really your enemy. It's not like a Chapter 7 trustee maybe, whose goal is to take your assets and sell them. Usually the sub 5 trustee's goal is to get a plan confirmed. So, and from the creditor standpoint, things are a little bit different, but, you should at least have open eyes and know what you're dealing with going into it. So what else? In terms of plan confirmation issues, this is what I look for. And I've already filed objections to probably 7 different plans. I've entered stipulations. I haven't objected to others. First of all, if I'm the dispersing agent, which I am, if it's non-consensual and the plan does not provide otherwise, if I'm the dispersing agent, I want to know real simply, who do I pay? And many plans are not written that clearly, and it's not clear to me. And I want to know with scientific certainty. I don't want to have ambiguity later on. If I'm the dispersing agent, am I getting paid for that? It's not in the form plan, but you should put something in there, take it into account in anything, have some sort of procedure for that. Here's something where I guess my opinion may be a little bit different than Judge Bonapfel. It's not that simple. In the event of non-consensual confirmation, Section 1186 indicates that post-petition earnings, post-petition assets are property in the bankruptcy estate. And so the question is, if you confirm a plan non-consensually, does property revest in the debtor? And actually, I apologize. The only reason I even know about this issue is because of Judge Bonapfel's treatise in the area. So I take that back. No disagreement. But the point is, 1186 clearly says that until the case is closed, which is years after confirmation, earnings, property that would have been property of the estate ordinarily, all remains property of the bankruptcy estate. So you have this sort of conflict between Section 1141, 1141B specifically, that says, unless otherwise provided in the court order, confirmation revests assets in the debtor, and 1186 that contemplates the opposite. And so I've actually objected to many plans unless they say that assets don't revest upon non-consensual confirmation. And this ties into another issue, by the way. I don't want to get into the plan confirmation in too much detail, but keep in mind that this is not Chapter 13. Chapter 13, the statute says that the court shall confirm a plan if it satisfies the best interest of creditors test, and if projected disposable income is paid to creditors. The statute actually says the court shall confirm the plan. Here, the court is only supposed to confirm a plan non-consensually if it's fair and equitable. And then the statute in 1191B says that fair and equitable includes. And then they talk about the payment of projected disposable income. And the reason that's so important is the word including, and I think Section 102 is defined to not be limited. So these are things that are sort of the baseline. They have to exist, but it's not necessarily enough to get a plan confirmed. The point is, there will be circumstances where paying projected disposable income is not enough. I'll give you an example. I was just involved in a case where a corporation or an entity was set up to experience tax losses, so that the owner of the entity could then take those losses on their personal return. It was a pass-through entity. And what the court ended up doing, at least what the expert witness ended up arguing, is that the benefit to the shareholder as a result of those tax losses should be used to determine, what's a fair amount to pay the creditors instead of projected disposable income, since the company was set up not to have any income because of depreciation, write-offs, that sort of thing. So, 1191B is flexible. Determining what's fair and equitable is flexible. In any event, the point I was making, and again, this ties into the fact that a sub 5, I don't want to get off topic, I don't want to take up too much time, but a sub 5 trustee is required to appear and be heard at hearings regarding confirmation. This issue about property not revesting if plan confirmation is non-consensual comes up over and over again. And so I want to point out to you it's important. Keep in mind also that in defining fair and equitable, 1191C3B says that the plan has to provide appropriate remedies, which may include the liquidation of non-exempt assets to protect the holders of claims in the event plan payments are not made. Well, not revesting the assets, in fact, is such an appropriate remedy, I would argue, that protects creditors. So that's another issue out there as well.
Mark, we have a question from our audience, and I think it kind of flows from what you're talking about, because it sounds to me like there's a lot of code sections you just mentioned, and I'm wondering, and the audience member here has asked, would a debtor's counsel be better served by a lawyer sub 5 trustee or a non-lawyer sub 5 trustee? What are your thoughts?
I mean, I guess if they want to have someone that they can walk all over and sort of not have someone who's not objecting to improper claims of exemptions, for example, that sort of thing. Yeah, of course, you'd be better off than a non-lawyer. In any event, there are different ways of looking at that. It would be very hard for a non-lawyer to do this, but it can be done. There are some sub 5 trustees that are not lawyers. In any event,
I think that's going to do. I don't know what you've got in California. First of all, you don't get to choose your trustee. The U.S. trustee is going to appoint somebody. If you're worried about trustee selection, and it's arguable that you should be, figure out who's on the panel, or they call them the pool, in your district, who's likely to be appointed, do some work, figure out who you like, and then call up the U.S. trustee before you file and tell them why it is that whatever trustee you've selected would be your suggestion for this particular case. I've never had this question come up before, but I do know that the sub 5 trustee, the U.S. trustee, has different people. Some are not lawyers. They intentionally chose some non-lawyers for their financial expertise. I would not suggest that you say, I would like a non-lawyer so that I can walk all over her. That is not likely to result in the U.S. trustee appointing that person. But in any event, if that's what you want to do, I would suggest. One other thing I just wanted to underscore everything Mark said about the role of the Subchapter 5 trustee. And in particular, at some point, if there's going to be contests and disputes in the case, every time that a contest arises, the judge is going to say, and what does the Subchapter 5 trustee have to say about this? And you want, if you're representing the debtor, if you're representing the creditors, you're going to want the answer to be, well, I agree with your client's position. So it's very important to get the Subchapter 5 trustee in the loop. The better sub 5 trustees, the cases that have active sub 5 trustees, I think in general, from what I'm hearing, are working better.
I agree with that. Just a couple more points, by the way. You use the form. There's Form B425A. That's the form Subchapter 5 plan. Because if you don't use a form and use a custom drafted plan, I have to spend all this time comparing the two and pointing out the differences to the court, and it's just a waste of resources. Also, many plans are being confirmed before, by like month 5 of the case, which is before the 180-day governmental proof of claim bar date. And so when you do that, and if the IRS has not filed a $0 claim, I'm insisting that language be inserted into the plan saying that if there is such a claim, that it's treated pursuant to 1129A9 subsequently. So it's a little bit difficult to confirm a plan before that 180-day period, but it does happen all the time. In any event, keep in mind that if a plan is confirmed consensually, you're required, once the plan is substantially consummated, which is a very low threshold, you're required as debtors counsel to file a notice of substantial consummation within 14 days when that occurs. And once you do that, the trustee is no longer the trustee. Whereas if it's a non-consensual plan, the trustee remains as a trustee throughout the entire life of the plan, whether they are the dispersing agent or not. So that's an issue as well. The other issue is if the debtor, this is 1183B5, if the debtor ceases to be a debtor in possession, the trustee is supposed to perform certain duties, including operating the business of the debtor. And this is really important because when you ask yourself, what is a sub 5 trustee supposed to do? Keep in mind that 1106 does not apply with the duty specified in there. 1181 specifically excluded 1106 as well as 1104 from subchapter 5. So if you have a judge who says, I want to appoint a chapter 11 trustee, somebody needs to tell the judge, this is not a chapter 11 case. The type of trustee is going to be appointed. Really, the only additional duty they're going to have under section 1183B5 is to operate the business of the debtor. So it's a learning process for everyone. Finally, the other unusual part is sub 5 trustees are supposed to facilitate the development of the consensual plan of reorganization. Keep in mind that the U.S. trustee handbook actually says that is the primary duty of the sub 5 trustee. Sub 5 trustee really should be trying not to be an obstacle, not to take one side or the other, to be a neutral and to try to facilitate the consensual plan if possible.
That's interesting. Mark, let me interject. We've got a question from our audience. Can you file a notice of substantial consummation prior to final fiat?
Yes, I just saw that done in a case. That's how I know the answer is yes. Has the plan really been substantially consummated if fees haven't been paid? Well, if the plan is paying those fees over the next 5 years, the answer is definitely yes. If they're supposed to be paid all before the effective date, maybe not. And keep in mind again that 1191E is a special rule in subchapter 5 that allows you to pay professional fees that ordinarily have to be paid all right away, including sub 5 trustee fees. It allows you to pay them over time. But if the plan is confirmed consensually, then they have to be paid right away unless the claimant agrees to different treatment. So it depends. It depends.
Well, they have to be paid on the effective date, on or before the effective date, and that would depend on what the plan says.
Correct.
Substantial consummation is defined in the bankruptcy code, and I think it's in 1101. But in any event, it's a rather simple thing, and it substantial consummation occurs when payments begin. So it's pretty easy to get a plan substantially consummated. And if you have a consensual plan in subchapter 5, you can't modify it after substantial consummation.
Right. By the way, there's one more point I want to raise. It really raised the point number 6 in the top 10 issues of this new law. Section 1189 says only the debtor can file a plan. It's really interesting because there are other sections like when it comes to plan modification in 1193, it says the debtor can modify the plan, but it doesn't say only the debtor can modify the plan. Section 1189 is very specific. Only the debtor can file a plan. So even if the debtor is removed as debtor in possession, you're all of a sudden the trustee in possession who can't even file a plan according to section 1189, and sort of creates all these really interesting dynamics. And keep in mind that 1185B, 1185A is a statute for removing a debtor as debtor in possession in subchapter 5. Well, subsection B talks about reinstating the debtor. That's very unusual the way this code was drafted. It's really very, pro-debtor. They want the debtor to succeed. If the trustee is going in there, it's presumably for a temporary period of time. That's why 1185B is right there. And the trustee can't even file a plan while they're operating the business. So it's a statute in that sense, and a very pro-debtor statute.
And that means that part of the reason for all of this is, first, I don't think we mentioned this earlier, but in a sense, the sub 5 trustee is a substitute for a creditors committee. the sub 5 trustee is supposed to be looking after generally the interests of the estate and making sure, monitoring and supervising the case. So if the debtor is not, and the Subchapter 5 encourages reorganization of the debtor and wants the debtor to succeed, to reorganize. No question about that. But that does not mean that the Subchapter 5 debtor can just proceed willy-nilly without regard to the bankruptcy code and rules and just do whatever the debtor wants without consequence. So the debtor is going to, if the debtor is out of control and is doing things that a debtor in possession should not be doing, the debtor can get removed and the sub 5 trustee gets put in place. Statute also recognizes maybe the debtor can come clean and say, I'm sorry and I won't do it anymore. Can I please have my company back? And maybe gets possession again. But other than that, the trustee's there. And as Mark points out, that's a problem, because how do you, what do you do from that standpoint? And the answer is, because the trustee can't file the plan. So the answers are either the debtor's going to have to cooperate with the trustee in getting a plan filed that the trustee and creditors will accept. And if you've got a debtor out of possession, it's possible that it was instigated by a creditor who was unhappy. So it's either got to be a plan that the trustee will be happy with, or the case is going to get converted to Chapter 7, or the case is going to get dismissed, or, and one court suggested this, the sub 5 trustee is going to liquidate the debtor's assets in a 363 sale, just like, in the ordinary course of a regular Chapter 11 case, liquidate all the assets of the estate and then convert it. So those are the options.
By the way, keep in mind, I know probably most sub 5 trustees don't do this, and it's a lot of work, but I've definitely done it in many cases. What I'll do is I'll take all the pre-petition accounting data and I'll ask for QuickBooks backup files, tax returns, that sort of thing, and I have access to the tax returns. Then I'll, of course, question the debtor about their business model, which expenses are fixed, which expenses are variable. I'm trying to come up with a mathematical model of the debtor's financials. Then I'll compare that to the monthly operating reports that are filed during the case, see if anything's changed. I'll look at the debtor's projections that were given to the U.S. Trustee's office at the very beginning of the case. I'll take all that data and then I'll finally look at the projections that are actually attached to the plan. And I'll ask myself, is this consistent with the old projections? Is it consistent with the pre-petition performance? Is it consistent with the monthly operating reports? Is the debtor trying to pay too little so that creditors don't have to get, there's a lot of financial information that I have at my disposal, more than I think any creditor has at their disposal. And it helps. It helps. Sometimes I'm just surprised that you'll have a small company that's barely making it. And I'm just thankful that anybody wants to even run this business. And, if they want to pay something small, that's fine. Other times there are creditors who can pay quite a bit. But keep in mind that the trustee does have that information. Some trustees actually look at it, and that's part of how they advise the court.
Excellent. Thank you, Mark. And why don't we jump right into projected disposable income? Take a deep dive here.
All right. Well, go to this. This is a cram down confirmation requirement. And here's the language of the statute, 1191C2. And you'll note that there's two subparagraphs, A and B. The language in subparagraph A is in all material respects the same as the language in Chapter 13. It says basically pay projected disposable income for what I call the PDI period in a Subchapter 5 case. In a Chapter 13 case, it's the applicable commitment period. But you pay, which it could be 3 to 5 years, depending on whether you're above median or below median. So in sub 5, it's also 3 to 5 years for the PDI period, except the court determines how long the time period will be, not the level of income. So Chapter 13 does not include the language in subparagraph B. The language in subparagraph B comes from the Chapter 12 PDI requirement. Hold that thought, we'll come back to that. But it says basically, you can also satisfy the PDI requirement by paying the value of PDI over whatever appropriate period it is, instead of all of the projected disposable income. So we'll come back to this, hold that thought. So go to the next slide. Section 1191D defines what is disposable income. And it is in all material respects the same as the language in chapters 11, 12, and 13, except it does not base income on current monthly income as it does in chapter 13. And it does not permit deductions for religious or charitable contributions. And then also the means test rules do not apply in the case of an individual in determining expenditures. So with regard to individual cases, pre-BAP CPA chapter 13 cases may provide guidance on what expenditures for an individual are reasonably necessary in individual cases. And Mark mentioned my chapter 13 treatise earlier, and it's on Westlaw, chap 13 PP. And the section for this thing is on this issue is 828. So two general points about the PDI test. First, it does not apply if all impaired classes accept the plan. This is different from chapters 11, 12, and 13, where any individual unsecured creditor or the trustee can require that the debtor pay projected disposable income. The PDI requirement applies only in cram down confirmation. So in effect, it substitutes for the absolute priority rule by requiring the debtor to pay disposable income in order for equity to retain its interest. Second point, the time period, as I mentioned earlier, is 3 to 5 years as the court determines. 5 years is the maximum in a subchapter 5 case, whereas in a traditional chapter 11 case, it is the minimum. And in a chapter 13 debtor case, it's the minimum and also the maximum for an above median debtor. In a chapter 12 case, the time period is 3 to 5 years, but it's the debtor in a chapter 12 case who chooses the length of the plan, not the court. And so in determining how long this plan should be, we don't really have any analogous practice in other procedures to look for. So I don't know how I'm supposed to determine whether the period should be 3 years or 5 years. All right, so one question that has arisen at seminars like this across the country is whether the debtor must pay actual disposable income as opposed to projected disposable income. So go to the next slide for us again. So we know under A, that's familiar from chapter 13, as I said earlier. It says, calculate PDI, figure out what your income is, figure out what your projected expenses are, and pay that amount, usually monthly, in fixed payments for the applicable period. That's what projected disposable income, that's what happens in a chapter 13 case. Subparagraph B provides an alternative, and it says you can pay the value of the PDI over a period of time. And one would think, as I did, that this provision is intended to permit a cash out of PDI in a lump sum, something that chapter 13 doesn't permit. But my study of chapter 12 has uncovered something different about subparagraph B. I think it means what I just said, but it has another implication. This is where we're going now back to the actual versus projected issue. When chapter 12 was enacted in 1986, it used the same language as the chapter 13 PDI test, which is subparagraph A on your screen, which had come into the bankruptcy code in 1984. But in chapter 12 cases, courts began requiring that the debtor show at the end of the case and in connection with an application for a discharge that the debtor had paid all disposable income to creditors. And the court would then determine whether the debtor had paid all disposable income and would determine it retroactively. In other words, the debtor had to pay actual disposable income during the period of time. And a debtor would have to either pay that amount or the case would be dismissed. This case law would support the proposition that projected disposable income in a sub 5 case under the language of paragraph A, which is subparagraph A, which was what chapter 12 had at the time materially, should be determined on an actual basis, not a projected one, and would pose the interesting issue of whether sub 5 PDI should be based on a chapter 13 approach, which is determination of PDI at confirmation on the basis of projected income and expenses, or a chapter 12 approach, determination of PDI at the end of the case as a discharge matter on the basis of actual disposable income. The question is whether the chapter 12 case law on this point is still good law and applicable in a sub 5 case in view of amendments that Congress made to chapter 12 in 2005 in the Bankruptcy Abuse Prevention and Consumer Protection Act, our famous BAP-CPA statute. We mostly know about BAP-CPA because of the changes it made in consumer bankruptcy, but it did two things for farmers. First, it made chapter 12 permanent. Second, this is what added B to the PDI test in chapter 12. And at least one commentator at the time stated that the purpose of this amendment was to eliminate the retroactive determination of PDI, which was a hardship for farmers, and to put the chapter 12 PDI issue back into a determination of what is the value of the projected disposable income. If this is the case, then under B, a debtor can say, I don't want it to be based on actual disposable income. It has to be projected disposable income under sub B, as its meaning is in a chapter 12 case. And a debtor in general may prefer projected disposable income to actual, because if actual is better, it doesn't have to share it. And if it's worse, the debtor, as we mentioned earlier, can come back in and seek to modify the plan if it's been a cram down plan. And having said all of this, nothing stops parties from agreeing to use actual income and base distributions on actual results in the context of a consensual plan. So that's PDI in a nutshell.
That's great. That's interesting. Mark, unless you have something to add, I'm trying to move us along a little.
Just keep in mind that in the Chapter 13 context, Ninth Circuit's already decided that projected disposable income is not the same as actual disposable income, and therefore Chapter 13 cannot require that actual disposable income be paid. At the same time, Chapter 13, the court shall confirm a plan of projected disposable income is being paid to creditors, and if the best interest of creditors test is being met, whereas in Chapter 11, Subchapter 5, the court still has ultimate authority to determine what is fair and equitable, and can determine that what's fair and equitable is that actual disposable income be paid. So there's a lot more flexibility, in Subchapter 5 than there is in 13.
Very interesting. All right, I'm going to move us along. What do we have next? 1111B election.
All right, so there is a question of whether in practice we're seeing whether the standard is 3 years or 5 years. And I don't know the answer to that question. I've heard in one district of Florida, the norm seems to be 5, and in another district in Florida, it seems to be 3. So we'll see how all that plays out. So the 1111B2 election, For those who may not be familiar with 1111B2 or have not talked about it recently, here's what it says if we can go to the next slide. What it says is that an undersecured creditor, and let's assume that we have a creditor whose collateral is worth 30,000 and the claim is 100,000. So he's undersecured. Bifurcation tells us this creditor has a $30,000 secured claim and a $70,000 unsecured claim. So the 1111B2 election allows that creditor to elect to have its claim allowed as a fully secured claim equal to $100,000. So a creditor who makes the election has a $100,000 secured claim and no unsecured claim. So if the creditor doesn't object, it doesn't accept the treatment, how does the debtor cram down that claim when the creditor has made the 1111B2 election? Note that in traditional Chapter 11 cases, this has not usually been an issue because creditors don't want to give up their unsecured deficiency claim because it may let them control the vote of the unsecured class, and it may provide them a blocking position because the debtor may not be able to come up with an accepting impaired class, which is a requirement for cram down confirmation in traditional Chapter 11. You have to have at least one creditor accept the plan. So those requirements don't apply in sub 5. A debtor can confirm a plan even if nobody accepts it. So these things may become more undersecured creditors may use these more often in a sub 5 case. So cram down requires two things. One, the payments must have a value equal to the value of the collateral. This is simple. We all know this. So if it's a $30,000 claim, the creditor must receive payments that have a value of 30,000, i.e. they must receive 30,000 of principal plus interest over the payment period. Second, for an 1111B2 claim, the total of the payments must equal the allowed amount of the secured claim. So this means that the total of the payments has to be $100,000 because that's the allowed amount of the secured claim with the election. Now, how does that work out in practice? Go to the next slide. Here's a chart that shows how a plan can satisfy an undersecured claim over various periods of time. And so if we look at the 5-year period, to pay if interest is at 6%, then the value of $30,000 with interest at 6% requires payments of $580, a total of $34,800. That would be paid over the 5 years. So to get to a total of payments of $100,000, the debtor would have to pay an additional $65,200. And that would mean monthly payments of $1,667. If you can convince the court that you have 53 years and 4 months to amortize the payment, then the monthly payment on $30,000 is only $156.43, and those payments will total $100,000. So that may get into whether it's fair and equitable to amortize it over that period. Next slide. So the election is not available if the collateral is of inconsequential value. What does that mean? There are two ways of looking at whether something is of inconsequential value. One is to look at the value of the collateral itself. The other is to compare the value of the collateral to the amount of the debt. And there are two sub 5 cases that deal with this. In the body transit case, the court determined that exercise equipment worth $80,000 to secure a debt of almost $1 million was of inconsequential value. It used the compare the value to the amount of the debt. It's 8% of the debt. That's inconsequential. The VP Williams trans case involved a taxi medallion worth $90,000 to secure a claim of almost $600. And the court there said that is of that is not of inconsequential value, and really didn't adopt one test or the other, but said it was of consequential value under either test. 90,000 is consequential. The percentage is also consequential, but it criticized the comparison approach. So those are the two approaches. They're the only ones that I know of at this point. And that's what you need to get started on for 1111 B2.
Interesting. Yeah, I had a question about this one, and I wanted to kind of hear your guys' thoughts on it. As I read VP Williams and body transit, VP Williams refers to body transit's analysis of the inconsequential value exception. And what it says is, and this is on page 102 of the written materials, the court in VP Williams says that the court in body transit also referred to the desire of Congress to foster small business reorganizations under the terms of subchapter V, but I do not see how that should have any bearing on the interpretation of section 1111B. Congress also desired to foster other forms of chapter 11 reorganizations, but section 1111B applies in all chapter 11 cases, including subchapter V. And what I think the court is saying is that when you have a statute like 1111B that applies equally to all chapter 11 cases, is there something in the sort of streamlining legislative history to subchapter 5 that will result in a different result, sort of a different interpretive, or applying that exception differently in a sub V case versus a regular chapter 11 case?
Yeah, I think the answer to that is that there's probably nothing in there that says you should apply those things differently or in the context of a sub 5 case, other than the fact that we really want sub 5 cases to work. And if somebody, like in the body transit case, I mean, there's no way that debtor can pay $1 million over any considerable period of time. Although the judge is really interested in having a plan, he could let them pay it over 50 years, I suppose.
All right, well, let's go on to the next slide. Dischargeability.
All right, so as I mentioned earlier, when cram down confirmation occurs, different things happen than if consensual confirmation occurs, and one of them is dischargeability. Consensual confirmation, the usual 1141 rules apply, except for an individual, the debtor does get the discharge immediately upon confirmation in sub 5. But when a cram down confirmation occurs, the normal rules don't apply, and instead 1192 governs the discharge. Go to the next slide. Okay. And there are three principal differences. I went to that slide too early, but leave it there. There are three principal differences. First, the debtor in a cram down discharge does not receive the discharge until the completion of plan payments. That's corporate or individual. Second, any debt to be paid beyond the 3 to 5 year term of the plan, whatever it is not discharged. Think a mortgage in a chapter 13 case that's cured and reinstated, same type of concept. And then finally, now we can look at this slide. The statute states that any debt accepted from discharge under section 523A is not discharged. And it says it in somewhat interesting language and creates an issue of whether that applies to make 523A exceptions to discharge also applicable in a corporate case. And I won't go through all of the arguments because we've got other things to talk about, but there are two approaches. There are chapter 12 cases based on the identical language in chapter 12. Chapter 12 does permit an entity to be a farmer debtor. Those cases say, yes, the exceptions do apply to a cram down discharge of an entity. The three chapter 11 or the three sub 5 cases have reached the opposite result in sub 5. Garrett, this goes back to the question of whether sub 5 makes a difference, and it could well be that part of it is we really don't want to have these things mess up subchapter 5 cases. But the sub 5 cases say that the 523A exceptions apply only to an individual, not to the discharge of an entity, even in a sub 5 case.
Excellent. All right, Mark, unless you have something to add, I'm just going to try and move us along as quickly as possible.
Keep moving.
Excellent. Okay. All right. Issues related to removal of debtor in possession.
Mark, I've said my piece.
Just keep in mind that the standards for removal of a debtor in possession in subchapter 5 are a little bit more onerous. The statute talks about gross mismanagement as opposed to just mere mismanagement. Again, section 1185A. The language is a bit different than 1112. And then 1185B immediately talks about reinstating the debtor's debtor possession. In the same breath that they remove you, they're already talking about putting you back in there. Again, while you're removed, the trustee can't even file a plan. So there's a lot of reason to put the debtor back in there. And it's just different. It's harder to remove. It's not harder to convert to Chapter 7, but it's definitely harder to as debtor in possession.
Excellent. I wanted to point out also the Central District of California has local bankruptcy rules that we issued earlier, I think it was last year, that kind of relate to some of the reporting duties that happen when you remove a debtor in possession, because it's interesting how the federal rules kind of deal with that. So at any rate, it just occurred to me to mention that. So if you're in the Central District, at least you can kind of look at those rules, get some guidance. I'm going to move on to the next slide, unless there are objections. Consensual versus non-consensual confirmation.
Again, here, if it's consensual, the trustee's out of the picture. Trustee fees stop accruing. Yeah, the debtor gets their discharge right away. They don't have to wait 3 years to get their discharge. Assets reinvest right away. At least there's a strong argument that 1141B should apply, that assets reinvest on confirmation, not 1186, because 1186 only discusses what happens in the event of non-consensual confirmation. It changes the definition of property of the estate if confirmation is non-consensual. So there are really many advantages for the debtor if confirmation is consensual. The only possible disadvantage is that there's no ability to modify the plan. 1193 only gives you the ability to modify the plan through the date of substantial consummation if confirmation is consensual, whereas if it's non-consensual, you can modify it at any point in time.
And I think it's particularly important, again, this goes back to individual cases. In an individual case, property of the estate is not going to vest in the debtor, is not going to remain in the estate. It's going to vest in the debtor. This means if there's a post-confirmation default, that anything that the individual has acquired post-petition, think the debtor's in an automobile accident after confirmation and has a big personal injury claim. If that's property of the estate, if the case gets converted, the trustee and the creditors get all that money. If the property of the estate has revested in the debtor, that's all the debtor's money. That's different from traditional Chapter 11. And so that's a key feature for an individual to want consensual confirmation.
That's correct.
And I think we have some slides on that too. So,
yeah. And by the way, sorry.
Go back to that other issue just a minute.
Go back to that slide there.
Before that, yeah.
Who makes
right
payments? Who makes payments to creditors? So go ahead.
Well, I was going to say that in cram down confirmation, the trustee makes the payments. I've had a lot of people say that we really don't want the trustee to do that. The plan can provide otherwise. Termination of service of the sub 5 trustee happens in consensual confirmation. Sometimes people have said, but we want the trustee to do something. We want to liquidate assets, prosecute claims, monitor the case or something. One of the earlier questions was, what changes might there be in sub 5 after 2 years? One of them would be to make it possible to keep the sub 5 trustee in place a little easier than it now is. Property of the estate vests, as I said earlier, in the estate, remains in the estate in a cram down confirmation. But again, in both cram down and consensual confirmation, It's unless the plan says otherwise. So these issues can be dealt with in the plan or order if they're important. And if you're worried about remedies and default, look at my materials. And it is important how vesting works, maybe. We
And
talked about the others, I think.
And I think we've substantively hit every slide, and it is 1:30. So unless you guys want to talk about anything further, this concludes the program. I want to thank our speakers. I want to thank our audience for the fantastic questions that they were dropping in, and you guys have a good weekend.
Thank you, Garrett.
Thank you all very much. I enjoyed it.
Thank you. Bye, everybody.